This is Law Bites, a podcast with Michael Geist. Welcome to the 100th episode of the Law Bites podcast. It's fair to say that when I started the podcast back in 2019, I wasn't thinking about 10 episodes, much less 100. I simply wanted to find another forum for discussing digital policy with a Canadian perspective, and a podcast seemed like the right avenue to do it. Along the way, the podcast has been more work than I might have expected, and also a lot more fun. I've been privileged to have an incredible array of guests: law school colleagues, experts from around the world, politicians, privacy commissioners, business executives, and community leaders. I'm grateful for their time and willingness to use the podcast as a way to bring their thoughts and ideas to a broader audience. I'm also thankful to the many listeners who provide feedback and tune in each week, and I'm particularly grateful to Gerardo Lebron Leboy, who not only created the music that accompanies each episode, but provides the essential editing and technical support that makes the podcast a reality. The role of the public and the public interest has factored prominently into many of my podcast conversations. I could think of no better guest for the 100th episode than Osgoode Hall Law School professor David Vaver, widely and rightly viewed as Canada's leading IP expert. Professor Vaver, who's a recipient of the Order of Canada, provided the scholarly grounding for the emergence of user rights and copyright in Canada and around the world. In this episode, he gives a masterclass in the history of copyright, the emergence of user rights, Supreme Court of Canada copyright jurisprudence, and the potential for future copyright reforms. David, thanks so much for joining me on the podcast.
My pleasure, Michael.
Yeah, it's great to have you. I never thought I'd make it to a 100th episode, but here I am. And, users' perspectives have really played a prominent role on many, many of the episodes. Doesn't matter the issue. There's a commonality when you think about some of these issues, and it's that kind of public interest user perspective that cuts across digital policy. And so having you come on to talk about user rights, I think is really appropriate and really a wonderful way to mark that 100th episode. Now, as you obviously know, and I'm sure some listeners know, that the notion of user rights in copyright in particular burst onto the scene with the Supreme Court of Canada's CCH decision back in 2004. And they drew notably on your work, of course, including that user rights, and I'll quote, "user rights are not just loopholes. Both owners' rights and user rights should therefore be given the fair and balanced reading that befits remedial legislation." And so why don't we start? I want to talk about some of the development of the case law recently and where things might be going. But why don't we start with the development of user rights within your own work? Can you describe how you began to articulate this vision of a rights-based framework for what others previously described, and I guess we should note some still describe, as a limitation or exception?
Yes, well, thank you, Michael. The number 100 is significant in another respect, as you know, that this is the year when the 100th year since the introduction of the Copyright Act of 1921 of Canada. So here we are in 2021, discussing something which was latent in the law in 1921, but as you say, burst on the scene, apparently to the surprise of many, although there it was, hiding in the bushes, only needing to be lured out by a cheerful court. You say that it burst onto the scene in 2004. That's quite right in one way, but I think what a lot of people have ignored was that the Court of Appeal, the Federal Court of Appeal, which gave a judgment from which the appeal was taken to the Supreme Court. It also quoted from my book, and it started talking about user rights in that language as well. So it laid the foundation in 2002 for what the Supreme Court laid down. And in that sort of way, we in fact see that this is not only the decision of a 9-person court of the Supreme Court of Canada, but also 3 other judges in the Court of Appeal as well. So it ought to have attracted some greater attention in that, just from that perspective. Well, I guess I came to this in this sort of way. I've been attending lots of conferences, as we do, and I came away from many of them dissatisfied with the way in which people were analyzing this field. And it just didn't make sense to me. It didn't make sense to me in a semantic way, and it didn't make sense to me in the context of balancing rights, and it didn't make any sense to me in terms of policy. So in a semantic way, I mean, we look at the Act. The Act says what owners' rights are, and then it says what is not an infringement of copyright. It's said in those words. It is not an infringement of copyright to do a whole bunch of things. So it seemed to me, semantically, that owners' rights stop at the point where others are able to do things which don't infringe the owner's rights. So it just didn't seem to me in terms of language that this was an exception, no more than having an island in the middle of a sea where you say the sea is an exception to the land and the land is an exception to the sea. You don't talk in those ways about physical environment. Why would you talk about that sort of way in a legal environment? So I thought the semantic argument was a jumping off point, but as soon as one went into that, of course, you started going into the question of balance. And we know that rights that are given in almost any area are not absolute. They are balanced off against other people's interests. And the question of balance, though, it's important to be quite clear semantically about it. Once you start talking about balancing rights against limitations and exceptions, that's the end of the game. You're talking about balancing different entities. So it seemed to me that what was wrong in talking about users having rights? There was nothing wrong with it unless you went into a very pedantic sort of argument, as one has with some of the legal philosophers who talked about rights. People don't have rights unless there are correlative duties and so on. But that is a very technical version of what rights mean. One of the main definitions in any dictionary, including the Oxford English Dictionary, including Samuel Johnson's dictionary back in the 18th century, of rights, is simply entitlement. Some entitlements you have that you're able to transfer, and some you're not. Why would you call one set of entitlements that are transferable rights and another set of entitlements that you have exceptions? It made no sense. It doesn't make sense linguistically, it doesn't make sense in policy terms, and it doesn't make sense if you're trying to balance things. So I came with that sort of thinking into the subject. And then, of course, as soon as you started doing a bit of research, you saw that this is not something terribly new. This is, we seem in the 20th century to have developed a view of copyright, which somehow has been foisted on us with interest groups who shout loudest and talk in terms of rights and limitations and exceptions. And I think my work was designed to counter that. I'd say I don't understand in both in terms of policy, in terms of technicality, in terms of linguistics, why it is justifiable to look at this area in that sort of narrow and crabbed way. It doesn't lead to any sensible conclusion. The only conclusion that you can come from is that owners are people who have rights, and everybody seems to be indulged as a matter of sort of noblesse oblige. And we let you do these things because we're owners. These are exceptions, things that have to be closely confined and narrowly construed. That made no sense either. It was counter to our own statute and the or interpretation legislation, which said that all legislation requires to be interpreted in a fair, large, and liberal manner, and that means every provision. Why would you interpret rights benevolently, beneficially, liberally, and then go on to another provision and say, well, this has to be interpreted contrary to that, and not in the way in which the Interpretation Act says that all statutes have to be interpreted and all provisions have to be interpreted. Suddenly we come up to provisions which we're supposed to interpret narrowly. And I say, well, where do you get that from? Where does that come from? It doesn't come from our law, it doesn't come from anybody's law, it's contrary to our law. So it's, as you see, it's a mixture of ideas. It's not a single concept that brought me to this situation. It was a confluence of ideas which I think pointed irrevocably and irretrievably to the conclusion that users had rights and that they were just as important as owner rights. And in fact, what is the point of copyright if it's not used? If there is no hierarchy in copyright which says owners are the people or owners or authors, although authors somehow get sidelined very quickly as soon as there is an assignment of copyright, a transfer of copyright, and the thing is really about owners versus users. So why is there a hierarchy where owners are treated as somehow higher up in the pecking order than users? That made no sense at all, because if you have no use, there's no point in copyright at all. Those were basically my thoughts, and fortunately, one or two judges initially appreciated the point, especially in an era after we have had the Charter of Rights and Freedoms, where courts were talking more in terms of rights of people and not talking in terms of the narrow concept that some lawyers have of rights, that if it's not something that you can sell, then it ain't a right. That's not the way in which the Charter of Rights and Freedoms was written. It's not a charter of exceptions and limitations. It's a charter of rights. The right to vote is not transferable, and yet there it is in the charter. So there's, I think that my writing came at an opportune moment in the history of the Supreme Court's jurisprudence, and it was really a door that was waiting to be opened.
Yeah, no, I think you're right about that. It's quite clear. It was obviously a unanimous decision, and coming after Vaver, you started to see a bit of a shift, and this marked a dramatic shift. I want to come to some of the reaction post CCH in a moment, but amongst the many different influences that you mentioned, one was the history, that when you started unpacking where things had been, that it was there. In fact, when you wrote about the CCH decision, you talked about, you stated, and I'll quote it, in talking of user rights in the 21st century, the Supreme Court of Canada has resurrected, perhaps unwittingly, a usage and tradition stretching back into the 19th century that had become obscured for most of the 20th century until Patterson and Lindbergh drew attention to it in their 1991 work. Can you talk just a little bit about some of that historical foundation that underlies this notion?
Yes, I think that's right. I think it is important. So in a way, we've forgotten how all-embracing, all-encompassing copyright has become in the 20th century. In the 19th century, you didn't have a great deal of need for a concept of users' rights because owners had so few rights themselves. So owners didn't have the right to translate anything. They didn't have rights to dramatize, which was really, so now we look at it, it's quite shocking to think that you could put on a play called Great Expectations and based upon Dickens's work, and Dickens could not in any way prevent that. that's looking at it through the eyes of the 20th century. So you didn't talk a lot about user rights then, because users had plenty of rights. They could translate things, they could dramatize things, and lots of work was simply unprotected. So, and moreover, the concept of what was an infringement of copyright was quite sensible. What it talked about was unfair appropriation. Was the touchstone of infringement. You could appropriate for other people's work. It's only when you did that unfairly, and what unfairly meant, I'll mention in a moment, only if it was an unfair appropriation was it considered an infringement. So what was unfair? Unfair meant that it somehow injured the work of the copyright owner. It damaged him in some way. It undercut the value that he wanted to get from his work. And I think there's no better example, actually, of this than the first major book, or certainly in the second half of the 19th century, in England on copyright. A book by a fellow called Coppinger, who was a young barrister who wanted to make his name, and he decided to write a book on copyright. So what did he do? He started writing, and then but before he started writing, he looked at a lot of other books. He looked at one in particular in the United States by a writer called George Curtis. And Curtis had a book on copyright. And Coppinger, the English barrister, didn't feel any compunction in taking great chunks of that work and his work selectively. The best part I liked was when he took the entire section on what constitutes a copyright infringement and wrote it virtually verbatim in his book. There's a sort of irony that because neither statute in either the American statute or the British statutes at the time had any definition of infringement. You had to sort of make it up. The courts made it up as they went along by saying, well, it's not everything that takes a little bit from somebody else's work is an infringement. It's got to be unfair, and we've got a few criteria to determine when it is unfair. Well, those criteria were written out by Curtis, and Coppinger had no compunction whatsoever in copying them almost literally, even to punctuation. And what I found was interesting, not a peep that we know of out of Curtis in complaint. And none of the writers of the time, legal writers who recognized this copying by Coppinger, I should call it Coppinger the copier, you may as well call it. None of them called this piracy and the various other defamatory things that denote that people that take bits out of other people's work are called. It was perfectly acceptable. Why? Because Curtis's sales didn't fall one jot because of what Coppinger did. They didn't fall one jot in the United Kingdom or the United States, nor did Coppinger's work get any additional buyers in the United States or any additional buyers in the United Kingdom as a result of what was done. So there was no harm at all to Curtis's work, to his rights. And we find, in fact, as we go on, and this is, I think, the interesting part, that the language of people having rights of fair use started becoming not uncommon in parlance in England. So much so that when fair dealing was first introduced as a statutory concept in the UK's Copyright Act of 1911, the then current editor of Coppinger's book. It had gone through a number of editions. It's now in its, I think, 16th edition and counting, but I think it was about the third or fourth edition there. But Coppinger had since passed on, and the work was being done by his son-in-law, who was a barrister. And the son-in-law, who's called Reaston, talked about the 1911 introduction of fair dealing and said, well, why is this here? Why do we need this? Well, people already have, and he called them rights of fair user of work. What does this add to the law? It does nothing. It's just going to be mischievous. So that was the state of the law at the turn of the century, at the turn of the 20th century, and it became obscured, I think, because the constant pounding of interest groups here has obscured it. The trouble, of course, was that even barristers like Coppinger, they made their money out of getting out of enforcing the rights of owners. There was no money in user rights at that stage, or for quite a little time later, and we find that with the subsequent editors of Coppinger. That was so. The United States, I think the interesting thing you mentioned, Patterson and Lindbergh's work in 1991, they came from it. Patterson was a very fine copyright professor in the University of Georgia, and Lindbergh was a English professor. They wrote their book on user rights in copyright from a First Amendment perspective, the United States perspective, saying, look, we've got all sorts. Copyright is something which cuts down freedom of speech, and we have to reconcile it with the constitutional right of free speech. And we can do that by recognizing that users have rights of expression just as much as owners have. So they came from it from that perspective, less from a historical perspective, going back through the 19th century case law, than from a First Amendment perspective. And I think that's perfectly legitimate. When you come to CCH, we have, it is an extraordinary decision in this sense that here we have the most expert panel you could have on the kind of work that is being talked about, right? We have cases where you have judges telling you what is a fair dealing with a work of art or with a piece of music, and judges, for the most part, with one or two exceptions, know no more about art or music than the person in the street. But that wasn't what the CCH decision was about. The CCH decision was a serendipitous decision in this sense, that publishers of legal works, copyright, the works of law reports reporting judges' decisions, monographs in compilation of books, textbooks. They came to court, since they couldn't get anywhere with lawyers or the Law Society. They came to court and said, look, the Law Society, which has a Law Society of now Ontario, then was called Law Society of Upper Canada, you have a library and you have our books in it, and lawyers who are doing research use your photocopy machines to copy bits out of our books. And there are people out in Northern Ontario, lawyers out in Northern Ontario, who ring in or dial or send in fax in saying, look, we don't have any books up here that in our community, but I really need to have access to this particular case or that particular book and that particular index. Can you send me a copy of it, asking the Law Society librarians? And the Law Society librarian would duly fax them the relevant material. Not entire books by any means, of course not. No one was going to do that. Everybody knows that's an absurdity. You're not going to send, someone says, I have a problem on the law of copyright. Why don't you send me all of Fox's entire book on copyright? No one in their right mind is going to do that. They know straight away that's absurd. But what was being asked for was, section on musical work. What is a musical work? What is infringement of a musical work, or so on? And that would be sent, and perhaps with the case as well. So the publishers said, well, you, Law Society, you're authorizing infringement. You're letting people infringe by having these photocopies machines. It ain't good enough just to put a notice on the machine to say, be decent, be good, don't infringe copyright. You've got to do more than that, and you're not doing more than that. And anyway, what is being done is not fair. It's not fair dealing. You're taking holus bolus works and judgments and of the reasons for judgment with all our additions to them, and you're taking indexes and all the rest. Well, here you had the court, a court of lawyers, being asked to decide what is a fair way to treat legal material, taking into account the needs of users, including their clients on the lawyer's side, as well as what is reasonable for publishers to ask for in this field. How is it reasonable for them to say you're infringing copyright when you copy a judge's judgment? Well, you've got no copyright in the judge's judgment, and just because you've stuck a few things in it, which are head notes and catch lines, and you've created some value, additional value for it, for sure. And you may even have a copyright in that additional value, although not in the judgments themselves. I mean, it seemed as if the lawyers, the law publishers, were saying that their version of the judge's judgment had copyright. Well, that was a fascinating suggestion in itself. How is that going to be? Judge can't quote himself again because you've corrected some of his spelling or some of a grammatical infelicity or something like that. And that gives you the right to stop the judge using that again. I mean, it became at one point an absurdity. But even in the bits where they did have copyright, where the court said this is really necessary. This is necessary. The copying that the Law Society knows about and that lawyers are doing is reasonable. It's fair. They're not taking the entire book. In a way, they are publicizing the book, they're giving it additional validity and authority. So, so long as you keep within reasonable boundaries, so long as you don't take too much of somebody's words, so long as you don't cut into the value of what they're doing, what's wrong with that? And so that's what the court decided, and it decided it in a most interesting framework because the publishers came into court saying the Court of Appeal had interpreted this all wrongly. There's no such thing as user rights. It's wrong to interpret fair dealing broadly. You've got to interpret it restrictively. That was the argument, and the Supreme Court of Canada basically said, why? Why should we interpret it restrictively? This is an area where the legislature hasn't granted copyright for the sake just of owners of copyright or authors of copyright. It's granted it for the public's benefit. There's no public benefit in giving somebody a right without somebody being able to actually the right to control copying. If there's nobody to read it or use it, what's your point? If this is a right that has been given in the public interest, for the public benefit, including the benefit of owners and authors and users. And we have to balance off all those various interests and not give priority the one to the other.
Yeah, no, and certainly that emphasis on balance is one of the things, of course, that struck a lot of people. Now, coming out of that decision and its aftermath, there were some that still remained pretty skeptical, especially around the issue of user rights. Some were saying it was simply rhetorical or it was obiter. In fact, there was certainly hostility, I think, from some of the rights groups, and it's fair to say even a bit of skepticism still from some education groups who didn't dive in with both feet, certainly on fair dealing, and we're still a bit reluctant. How did you see it? Did any of those reactions surprise you?
No, none, not really. They didn't surprise me. I think the ones that said this is obiter, this is just a passing comment by the court. Really, I think they were dreaming in Technicolor. I mean, when a Supreme Court writes a judgment, a unanimous judgment, under the signature of all 9 judges, every word in that judgment has been subject to scrutiny by all of them. And if one of them doesn't like anything in the judgment, they will write a dissenting opinion, or they will write it if they say, "I agree with the result, but I'll disagree with the way you stated it." And this is why. And this is very common. The extraordinary thing was that this was a unanimous decision, carefully penned, no grammatical errors in it, no slip of the tongue. And those, as I say, those who said this was rhetoric, and obviously not in the Greek sense, but the rhetoric is just padding or just useless oratory, I think had mistaken what had occurred. They'd mistaken what the Federal Court of Appeal had said so clearly and concisely, a unanimous decision on this point. And they mistook what the Supreme Court was saying. They didn't have to put it in that way at all. Then there are lots of ways to decide this case, but you didn't have to write it in this sort of way. Yes, no, I think you can lead a copyright owner to water, but you really can't make him think. And the education groups, well. Education, yes, I think they were a bit flustered by it, really. I think the problem is that it's a general problem with the copyright law. You have a lot of people saying what you can and can't do, except very little of it has anything to do with the statute. You actually look at the legislation and look at it carefully, understand what it's about. It's actually gives a fair amount of liberty to people to do this and that, and I don't think, and I think it's true that universities, on the whole, we're not very knowledgeable about this. Look, it's not just universities. I found my discussions with publishers, how publishers didn't have a great deal of knowledge about the copyright law. I think it was Jack McClellan that said back in the days that when he was the part owner of McClellan and Stewart, said, copyright has got to be the most boring subject in the world, and that's right. Anything is going to be boring if you don't understand it. And I think publishers are as responsible as anybody else at that time of enormous ignorance about the law that they were dealing with. They dealt with contracts, right? The argument was, look, I can do anything by contract. What do you do with what by contract? But if you don't have a right to do it, if the right isn't there, well, what are you contracting about? So that's. I wasn't surprised. I wasn't surprised at all. The only thing that I was I was. No, I don't know. No, I don't think I was surprised at all at the result. And what I was concerned about, of course, was whether the court would continue in this line, or whether it was a one-shot wonder. That's true. That part I was a little apprehensive about. But then on the other hand, as I say, it's a hard statement to walk back from. You have said it's a user right. The next step will be to look at the implications of what you've said. And that's what's been happening since 2004 at the Supreme Court level.
Yeah, no, I think I think you're right. That provides a really nice segue, actually, to 2012 when we get the copyright pentology, a series of 5 cases that included several that involved these issues, and I think it's pretty clear that some saw it as a chance to unwind the user rights framing. That obviously didn't happen. What are some of your thoughts on what certainly seemed like a solidification of that user rights as a central part of the copyright balance, and as you say, the beginning of an exploration of some of the implications of what that means?
Yes, I think the copyright owners, I think, really still didn't understand the environment in which they were working. I think it's fair to say. They still came back saying, interpret this narrowly. And of course, judges sitting there said, well, look, 8 years ago, we called this a user right, and we said it ought to be interpreted liberally. And what are you telling us now we should be reversing ourselves? What's your justification for that? Well, we had no justification for that. Just rhetoric. So, well, you argued this in 2004 and you lost. So why are you coming back and doing this again to us? And you had not only did you lost in grand style in both the appeal court and the Supreme Court. So I think there was a strategic mistake on the copyright owners in coming forward in that sort of way, and they came forward in a way which made them look greedy. I think if there's one thing that you know about law or about life, you may very well have a right, but it's not. It doesn't mean that you have to enforce it to the hilt or argue that it should be enforced to the hilt, because sometimes you just look damn greedy. And I think that the court, at least a majority of the judges there at least, looked at this and say, well, how many rights do you want, and how many rights do you need, and how much do you actually want to make out of this right? And can you be better off by splitting your rights and stacking them than if you just were a simple owner and were just asking to exploit it in a regular way? You shouldn't be better off simply because you're able technically to split your rights in all sorts of directions and say, oh no, it's not really the owner, it's not owner A who is asking this is owner B. Well, don't you think the court can see behind that? And they did. The court, so as a majority, did. Now, you're right. I mean, you've written some great work on this, Michael, yourself, so I'm not telling you anything new about it. But it's the court decided, I think, does it make sense if you're selling music and you have rights in respect of that music? Does it make sense to say that putting a little clip on to encourage someone to buy that music ought to be a copyright infringement, and we should get money from the person who wants to have a little listen to a piece of music in a degraded form, not in hi-fi, high resolution sound. What sense does it make to say that they can't do that without someone having to pay them for that? That wasn't the law across the Atlantic. There was it was being decided quite clearly that the right, someone that went into a record store and took a pair, as you could in those days, and took a pair of earphones and asked the clerk behind the desk, could you put on that bit of music, I want to listen to it to see whether or not I want to buy it. Of course, that occurred and occurred regularly. Copyright owners sued to say that was an infringement. The court said, "Well, of course it's not an infringement. This is a perfectly acceptable practice." And in a way, we didn't have anything like the statutory right that was relied upon in the United Kingdom for that particular result, but it was the same sort of principle, wasn't it? You'd say, why would you charge somebody to give them a little taste of your ice cream in order to sell them the whole damn scoop? Made no sense. And so I think it was a silly case to bring, and the result was a decision which the collectives and copyright owners generally certainly did not like, but they really asked for it. Their thinking made no sense in that sort of case at all. The case involving these photocopying in secondary schools, which was the other major case there, that involved a split in the court, more about whether or not you should just leave the Copyright Board alone to do its thing, or whether you should review them a bit more critically about whether or not photocopying was or was not a fair dealing. Well, the court's view that it could be taken as a fair dealing for the purposes of private study if teachers did it for the benefit of the students, that was certainly a liberal interpretation. It was an interpretation that again came back to the cultural roots of intellectual property and copyright. What do we have this for? Surely you want students to learn about your culture. You want to have the culture supported. You want to have it supported financially. Why would you stop people learning about your culture while they're students? And in order that when they become adults and have money to spend, they'll be spending it on books. We don't say, or books and film and theatre and all the rest. We want people to understand the full richness of what's around them, and just giving them a taste. Again, you're giving them a taste of what's going on through the excerpts from books or photographs or from snatches of music and all the rest. You're educating people to support your own culture, and they'll do it economically when they have the money to do so. You don't want an ignorant population, ignorant of its own culture. That's not going to support the arts. That's not going to support culture. That's not going to support anything. So in the long run, of course, it pays to encourage teachers, professors to make works available in a reasonable way. You're not going to, if you're teaching Margaret Atwood's books, you're not going to say, look, here's a photocopy of The Handmaid's Tale. That's for you. You can read it now. That's a fair dealing. Of course, no one was doing that. In a way, professors and teachers are very versed in the ethics of copyright, because they're both producers of work as well as users, and they're producers of work for the benefit of students and for the benefit of the public. So they're very well aware of what ought to be ethically the limits of what other people can do with their work, and you have to rely a little bit on their good sense. Of course, you're always going to get some person who doesn't do the job, who abuses their rights. There's always that. No one's going to stand up for that. No university will stand up for that, let alone copyright owners. The university polices these things in a way too. It doesn't want its reputation ruined by characters copying chunks of the library and handing it over to students. It's just not on. So so that's how I see the the decision on photocopying, which essentially said reasonable bits. Nothing wrong with that, and it should be encouraged.
Yeah. Now, speaking of university reputation, it brings us to the latest case, and the last case we can take a look at, which of course is the Access Copyright York University case, with again a unanimous court strongly affirming user rights, this time in a decision written by Justice Abella. I guess I should start just by clarifying whether or not you had any role in the case, given that you're at York University, but even more, any thoughts on that longstanding litigation between the collectives and the education sector, and on this decision as well, which feels a bit like it puts a capstone on sort of on the kind of the progression of these decisions that you've just been describing.
Yes, I have. I had no role in the case at all. Nobody asked me either for or against, for an opinion for or against. I think the university was scrupulous in keeping away from any of the legal academics, unless the legal academic wanted to interpose themselves in some way and give their opinion on the matter. I'm very conscious when I write about copyright and intellectual property. I try to remain as objective as I can, despite my being in a university. I do very little opinion work for others. I don't want to sort of be a party trees in any sort of way. No, the short answer is, that was the long answer. The short answer is no, I had no role in the case one way or the other. My thoughts on it, I think collectives and the education, and collectives can be useful for the education sector. I think, again, we just had a situation where there's just too much greed going on here. The access copyright was decided that it was not getting enough money per student. So for photocopying, they wanted more, and they upped their request to something like, I don't know, 5 or 6 or 7, 8 times what they had previously been getting from the universities under agreement. Well, what do they think was going to happen? I can't. And then they were trying to do this across the entire university secondary sector, tertiary sector, and knowing that this would have implications for other universities and other educational institutions as well. They could hardly expect that York would take it lying down, and I think and they haven't, and they didn't, and they fought the case, even though, and they slowly won, right? They lost, the university lost completely in front of the first instance judge, who said that the tariff that the Copyright Collective had got from the Copyright Board was mandatory. As soon as one person copied one book in the university, the entire tariff became payable for across the university. Well, stand back for a moment and think about the logic of that. There is no logic to that. And the judge also thought there was no fair dealing either. So went to the Federal Court of Appeal, and the Federal Court of Appeal finally understood the point. If one book is taken, that doesn't mean that you're going to get $25 per student because one student is given a photocopy. That makes no sense, and the court, relying on some careful work, historical digging and statutory interpretation, especially by Professor Ariel Katz from the University of Toronto, said no, this tariff isn't mandatory. It has to be. It is in effect an offer by the collectives, which the university is free to accept or not. If it doesn't accept, then it's potentially liable for infringement. But that all depends on fair dealing. But anyway, that part was good for the York. not so good was where the Court of Appeal said, no, the judge was entitled to say this was not fair dealing. The regulations that York had carefully put together in an attempt to allow moderate copying, they weren't fair, and the Court of Appeal affirmed that. So when it went up to the Supreme Court affirmed the Federal Court of Appeal's view that this wasn't a mandatory tariff, and which of course left the Copyright Collective in an odd situation. They weren't copyright owners. They only had a non-exclusive license to deal with copying, but they had no standing to ask for infringement, any sort of infringement remedy. But that, of course, left the university vulnerable as well, because that's the court said, well, if the wrong party is in front of the court asking for infringement, how can we make a declaration against people who aren't parties to this? That's the real copyright owners who aren't here. How can we make a declaration saying this is a fair dealing? So we won't do that, but we will say something. And what we'll say is both the federal initial judge and the Court of Appeal just got it all wrong. The fact that this is a user's right means you have to consider all the users, not just the person that you say is allegedly infringing, that's the university. You've got to say, who are they doing it for? Who is the actual end user here? Well, it's the students. And by not looking at their interests and whether it was fair that they be not able to access this work, was it fair on them? The federal court, the lower courts had not decided that question at all. They just simply said it's not fair for the university to do this. A public institution set up under for the purposes of educating the public somehow had got the public interest wrong in what they were doing. So Justice Abella, I think this was the last case that she heard before retiring, and quite appropriately wrote a judgment, since she had been quite instrumental in two of the other fair dealing cases in the pentalogy. I think as a final flourish by her, I think the judges were happy to let her write the judgment, and she said, I'm not going to make a declaration, I'm not going to say anything except that the lower courts really got it all wrong in terms of the perspective they took on who is the user and whose interests you have to take into account when you say, is there a fair dealing or not? So we come back to the question of collectives in the education sector. Well, I don't see why they can't have agreements on the uses which are not thought to be fair, and I don't see any reason why they can't hammer out a set of agreed guidelines. But it all comes down at the end to the question of money. You're going to have a set of agreed guidelines. Are you going to ask for the sky and beyond in terms of royalty fees? If you're going to ask that, well, you know that you're not going to get an agreement. You know that the education sector is strapped for finance. Where is it going to come out of? They're going to sack staff. Well, where is it to say that this is not a bottomless pit of money that you're going after? So I think that had the collectives stayed reasonable in their demands and in their royalty demands particularly, this case would never have come to court. But you get too greedy, you end up with nothing.
Yeah,
He's favorable about that too, isn't there?
Yeah, I think you're right about that, and certainly the role that Justice Abella played. I mean, it's striking to me how we've had a real complete turnover in the court from CCH to this most recent decision, and yet it's quite clear that the core thinking around balance and users' rights remains unchanged. Things are I think set now in Canada, at least in terms of how the court looks at it. Why don't we jump quickly to the notion of user rights on the global stage? After the CCH decision, you wrote about the lack of balance in the WIPO Internet treaties, noting that they have owners' rights and users' duties. I guess first, do you think anything has changed? Obviously, the Marrakesh Treaty seemed to at least open the door to greater user rights with respect to the rights of the blind and visually impaired. But more broadly, do you see a pathway for imbuing international intellectual property, whether through IP treaties or trade agreements with the same kind of notions that we've seen adopted by Canada's courts around users' rights?
Yes, that's a good question. I think we are seeing a seismic shift here. The European Court of Justice, which decides, in effect, the copyright law or copyright norms for all of the European Union, has been traditionally quite strong in favor of owner rights and authors' rights. A strong French tradition of protecting and treating authors seriously. But they are coming around. There are one or two now decisions from the European Court of Justice which starts talking about user rights and user interests, and these things having to be more seriously considered than they have in the past. And the European academics are noting this, and they're welcoming it, and they're running with it. And they're talking about Canadian courts and what they're doing there, and saying how much more satisfactory this is intellectually than this dead-end talk about owners having rights and authors having a few rights before the owner takes them all, and users having limitations and exceptions. What a stultifying type of analysis it is. It doesn't give any intellectual heft to this whole area. So I think we see it at the level of courts, and you're right, at the level of Marrakesh Treaty in 2013. Well, yes, we had provisions in our Copyright Act which was designed to assist people with perceptual disabilities, people who couldn't hear or see as well as others, and so needed to have different special access to works, not necessarily the same access that owners thought about giving them. So these treaties have looked at that and have imposed rights. I don't think we've changed our act significantly, because I think we had recognized that. I think we're recognizing user right. It's starting to link in, as it should, as a form of human right. And once I think that linkage is made, then I think we can talk more sensibly about balance, because the Universal Declaration of Human Rights back in 1948, straight after the Second World War, and its later treaty, the International Covenant on Social Rights, Social and Economic Rights, both of those treaties talk about the right to access to the world's culture as being a fundamental human right. And they also talk about intellectual property as being a human right as well. But I've got to tell you, it's the last of a long list. And as you'd expect, the right to health and the right to education and all the rest are serious rights. Right to non-discrimination, the right to equality. Those are serious rights. When you get down the list, well, okay, right to the benefit of culture is obviously important. Right to intellectual property, yes, right at the end of the list, and almost as an afterthought. So I think the linkage to user rights and the right to access culture and the right to access health are useful linkages, and I think that's where there is going to be some more growth of thinking here. After all, we have trade treaties and we have human rights treaties. which is to be paramount? Are we going to say that the right to health is less important than the right is more important or less important than the right to get a benefit from your writings or your inventions? If the population is dying, there's hardly any point in writing. Then there's nobody going to be around to read. So, you have to take human rights seriously in terms of the trade treaties as well. It's one of the things that I think will be coming down the pike. How far do the rights that you think that you have in trade treaties, mind you, those rights are expressly said to be balanced off. Rights and obligations under this treaty are supposed to be balanced off. How far those rights are going to be superior to human rights, or whether you have to reach an accommodation with them.
Yeah, no, I think that kind of discussion is something that we're seeing take place more and more, and that's certainly positive in terms of the direction that's going. Why don't we conclude with this? We're in the middle of an election campaign in Canada. Copyright is unlikely to be a major topic, but the prospect of ongoing lobbying for copyright reform is certainly with us. We see it certainly even in the immediate aftermath of the York case. We see it amongst several consultations that the government put out just prior to the election campaign. So entirely possible that we're going to see a big push for yet another round of reform in whoever forms the government. What thoughts do you have on potential avenues for copyright reform at this point in time? If someone granted you the pen, what would be some of your priorities?
Well, if someone granted me the pen, I'd probably start from the ground up and do a wholesale review of the Act, because what may have been good in 1921 or 1911, going back to the roots of the 1921 Act here, is that what we really want in 2021? Is it just we have this something which was contemporary with the Model T Ford, which we keep patching up, tossing on another layer of paint or sticking an aerial on here and there, but it's still this old bit of 1911, 1921 law. Isn't it time we started thinking about this area a bit more holistically and asking what's good, what's necessary for the 21st century in terms of where things have gone with the digital culture, with the internet, with the greater use of streaming and all of those developments? Have we really coped with that? Is it necessary to have a law which protects authors' rights for life of the author plus 70 years? In other words, something which, if the author is a young person, will run over a century. What is the justification for that? Especially when the right is transferred and the author's heirs don't get a cent out of it, except in some rare cases where you can claim reversionary rights, but not very often. So there are lots of areas that you could be looking at. The whole, when you have somebody come in to look at any institution and say, what is it? What's wrong here? What's right here? Where do we start? You generally start from ground zero and say, look, if I was designing this from the bottom up, to do what we think is valuable and economically and socially today, would I have designed it this way, or would I have gone about it another way? That's what I think really ought to be done with copyright. And we'd never have had that sort of look at copyright law. We've just been patching this old Model T Ford over years. If you give me a pen, first thing I would try to do is to draft something in language that somebody can understand. Copyright Act If you ask a person, an author, or a musician, or somebody who's affected by copyright, an artist, to read this act and try and figure out where they stand under it, they won't be able to do it. The law here is written in the most obfuscatory way that you could ever imagine. It's bizarre. It's a bizarre piece of law. In 1911, it was a relatively short piece of legislation, quite comprehensible. It has not improved with subsequent drafts. Lobbying, well, I remember when the 1988 British Copyright Act was being in the course of being amended, and somebody asked, why does it take 20 years or 30 years before any copyright law is really amended from the ground up or in radical ways? The response was, it has to be an entire new generation of parliamentarian, because anyone that was involved in the last review of the Copyright Act will remember what a nightmare it was. And we don't want to revisit that again. So it has to be a completely fresh parliament with no collective memory of what went the last time around, and it would be willing to do it. Is there any vote? Is there a vote? Are there any votes in copyright reform? I don't think so. Unless I'm much mistaken, we have the benefit of having the Minister of Justice, the Attorney General, as in fact being an intellectual property and copyright expert, one of those rare coincidences of that we have. But do you think that the Honourable David Lamatti will be out there saying, let's reform the copyright, let's go to the hustings on copyright reform? I don't think he will get a lot of support from his colleagues on that, and I don't think anybody in any other party would do it. So this is, in a way, it's reform without a vote. But it's a very, very serious reform. It's reform which says, which deals with people's freedom of speech, freedom of action, and their ability also to make money, their economic rights. There's no surprise that it's contentious. Always will be contentious. If you ever reach a copyright law where everybody goes around and says this is terrific, then you've got it wrong.
I think it's a great way to close, and I think that's long been my view, and I think the view of many in government, which has been that is a very tough policy issue, one in which you're never going to please everyone. In fact, in some ways, an indication of whether or not you've got it right is whether or not everyone is at least a little bit satisfied, and perhaps a little bit unsatisfied as well, given some of the balances. But you're also, I think, accurate in saying that this is not going to be one of the big issues of this campaign, but could be a big issue once we get back to Parliament, because it in the past certainly has proven to be, if they do move forward with reforms, issues that attract a lot of attention. David, this has been a true masterclass in both user rights, your role in it, and even more the development of Canadian copyright over the last couple of decades. So thank you so much. It's a truly wonderful opportunity to get to hear your perspective and see how things have unfolded over these last number of years.
Thank you very much, Michael. I enjoyed talking with you, and as usual, you had a perceptive round of questions, which made me scratch my head now and then to come up with something else sensible to say, and I hope that is the reaction of others.
It was fabulous. Thank you so much again.
Thank you.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.